Welcome everybody, Jordan Liu here. As was just stated, this webinar is part of a Financial Poise webinar series, Restructuring, Insolvency, and Troubled Companies 2025. Slides 8 and 9, for those of you who have the deck, will provide a summary of the series, and slide 7 summarizes this episode. And speaking of the slides, what you should understand from the get-go is that we won't step through the PowerPoint in any order. You won't have to listen to us read slides. In fact, we may not cover all the slides. This webinar, like all Financial Poise webinars, is a conversation. That's where the real value is in these panelists. And so it's totally fine for you to listen without looking at the slides, and what'll really matter is hearing those insights from our panelists. But I would ask you to keep the PowerPoint handy if you have it, because I'll try to indicate what slides our conversation is touching on as we proceed, so you can take notes. And the conversation, just so you know this, is meant for general educational purposes. And it doesn't replace the need to consult with your own attorney, accountant, or other appropriate professional, which we are not. This is for general educational purposes only. Turning to our esteemed panelists today, we have Stephen Nerger, a turnaround and restructuring advisor at Nerger Advisory Services in Park Ridge, Illinois. Richard Corby, a restructuring lawyer and litigator with the law offices of Richard J. Corby in New York. John Friedland, a corporate restructuring partner at Mudd Schellis in Chicago. And then you have me, Jordan Liu, a partner in the business litigation group at King & Spalding in Dallas. We appreciate you not spending your time and money just to hear infomercials about us, but you can read more about us if you'd like at slides 41 through 44, towards the back of the deck. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, please go to financialpoise.com/subscribe. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this on demand, or you have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episode, and we will do our best to get you an answer. A special shout out and thank you to our sponsor today, Max Asset, and also to our co-producers, the National Law Review and the Daily Deck. There's some info on these great sponsors in the materials. Without further ado, we'll get right to our program. Stephen, we'll start with you. Businesses and clients often have certain goals, objectives in mind when they're pursuing any form of restructuring. What are some of the most common goals you've seen in working with troubled companies? And what should those in charge have in mind when framing those goals?
I think some of the more common goals that I typically see, first off, eliminating operating losses. Usually that's achieved through some type of profit enhancement measure, whether it be cutting costs, improving margins, raising prices. The key goal is you need to bring costs into alignment with current revenues, not anticipated revenues, but where you are today. Another common objective is improving liquidity. Obviously, eliminating operating losses will improve liquidity, but there's other things that businesses can do, to improve cash. One of them is, improving accounts receivable collections, selling excess or slow-moving inventory, or selling off fixed assets that aren't needed. Another objective is, somehow restructuring debt, whether it be the secured debt, trade debt, or both. And the objective there is, again, try to get it aligned where you can service it, with the cash flow that the business is currently generating. Whatever objectives are part of the restructuring plan, there's several things management needs to really keep in mind. I think first and foremost is you got to get the business to a point where it's at least generating $1 of positive cash flow. If you don't do that, you're on a limited time frame in terms of, life expectancy. Failure to get to, positive cash flow not only will significantly impair your ability to restructure, in all likelihood, it'll derail it. I think another thing to keep in mind are your employees, especially those in, key positions. Many times, ownership doesn't give the credit to those people that they really deserve. They're smart people. They can really help in a restructuring situation. So make them part of your restructuring team. Bringing them together, making them a part of the solution, so that they work cohesively, towards that common goal.
Speaking of that, the restructuring team, Richard, if the directors and officers of a company perceive financial distress, is it appropriate to hire advisors like lawyers, financial advisors, and bankers? And where does that fit into the strategy?
Well, speaking as a professional, I say it's always good to hire more professionals. But
Right.
but seriously, I think probably you'd want to have a financial advisor first, particularly if you're having issues managing cash flow or collecting, or your receivables aren't coming in, or you're getting behind on your accounts payables. You probably want someone in to come in and probably, do a weekly, or sometimes depending on the severity, the daily cash flow analysis. Um, and with that, you probably want to have an advisor to interface with your lenders. If you have, it could be the smallest facility or it could be the largest facility. Your lender, a company will most likely have covenants, both non-payment covenants and payment covenants, that if the company is starting to get in trouble, they may start to trip covenants. And it depends on how aggressive their lender may be. They would want to basically reach out to their lender immediately, but depending on how well the relationship is with the lender. If it's a good relationship and the CFO or people in the finance department can call up, their main banker or lenders, that's a good thing. But if the lenders don't trust the debtor or the distressed company, it may make things more difficult. Um, so I think having a
Kind of, well, I was just going to say, kind of building on that. Say you hire the financial advisor first, you get somebody like Stephen in there. How do you go about messaging the distress to the market and customers and vendors? I mean, or do you? What's the timing consideration there?
I think the timing is key. Especially if you're a public company. If you're a public company and you've hired a financial advisor that is known for restructuring, then the sharks are going to be out. People are going to, customers, your competitors and employees could think, oh, are we even going to survive? So it's important to be honest and have a singular message to each group, whether it's your vendors, employees, or the market. Because if you have 10 different stories, it becomes like a game of telephone. For instance, if you have a large retailer and you're getting behind on paying some of your vendors, but not all of your vendors, your larger vendors could go to the press and say, hey, we haven't been paid in 3 months, or we're going to file a lawsuit because we haven't been paid in 3 months, or we're going to stop shipment of goods in delivery so we can cut our losses. So in that respect, you want to have a targeted message to the vendors. And again, it dovetails on what I said earlier of communicating with your lenders, um, and also your customers as well. As far as the public, if you're a private company, you still, depending on what sector the company is, if you want to let the public know that you're still in business, addressing issues, because you want to control the message. You don't want to have, the last thing you want to do is someone can, you know, says a layup becomes a half court shot, to use a sports metaphor. You want to control the message on what's going on, because once you lose control of it, you're playing catch up, and you want to be proactive rather than reactive when you're addressing a distressed company.
If we
Right.
could take a
Ju-
step back, I just wanted to overlay.
Sure.
So, you know, every situation is different, and it depends on one of the key factors is what's the distress, what's the issue that's causing the need. What's the title of this episode? Help My Business Is in Trouble. So what type of trouble? The title, I guess, sort of alludes to an operational issue. I mean, if I had to sort of intuit, but we all sometimes the company is just fine. The operations of the company are just fine, and it has too much debt because the current owner bought it and piled on too much debt. And if that's the problem, for example, there may be very little need and very little good that can come from any communication of the trouble, and it's just a conversation among the parties, the owners and the significant debt holders around a table. So it really depends.
Very helpful. And maybe John, if you could kind of stick with that theme for a minute and kind of help us understand how these different considerations may drive the strategy, from the stakeholders involved to the liabilities the business is looking to restructure. Maybe, I think this kind of starts on slide 14 of the deck, but this idea of what are the considerations and how they affect the path.
Oh, so that's the way we're going to play it. I volunteer an answer and then you just keep on me. Okay.
Yeah.
Well, let's go back for a minute to, Steve was talking about, what was the question was, what are the most common goals? And one thing I don't think we talked about yet was maybe I own a business and I'm 70 years old. It was a family business. My kids aren't interested in continuing. And I've got some personal savings, but the company has a lot of debt and I've got some personal guarantees. Maybe my only goal is to get the hell out and get relief from the guarantees, and I couldn't care less what happens to the business otherwise. That's one end of the spectrum. Another business goal would be, I want to sell it to my son-in-law, and we both want to make sure it's cleansed of liabilities, but we want to do it above board. So we come to professionals like ourselves and we say, how do we do this? And that's a thing that bankruptcy and other bankruptcy alternatives might be able to achieve. But I guess I'm departing because your question was what factors drive which alternative? Is that what you asked me?
Well, but I think you're really covering it because some of the factors are what are your goals, right? And if you, as you say, you're trying to get out from under a guarantee, that's a different world than if you're trying to recapitalize a business that you want to stick with personally. So, that's certainly going to drive it. And obviously the types of stakeholders you have and like what types of security packages do they have? Are you facing uneconomic leases or are you facing a revenue problem? Those are different.
That's right. And for example, if you would like to wipe out unsecured debt and sort of buy the company back free and clear, and you've got a secured lender with a lien on all your assets who you can play ball with, and a friendly Article 9 sale might be the way to go. But if you don't have any secured debt, that's not going to happen. So, the types of creditors are involved, like you said. What are the nature of the liabilities, right? Many liabilities, most liabilities can be cleansed through, let's say, an Article 9, an Article 9 or an ABC, but some liabilities you need the power of bankruptcy to get rid of. Some liabilities, even a 363 sale won't cleanse. You need to do a plan. So, that's another, those are some of the other factors. I don't know if there's any other bullets on the slide that you want to.
I may just overlay for a minute, as a litigator on litigation and judgments. Are you facing a judgment and you're trying to get a bond? Do you have the right kind of collateral to back the bond or not? Do you have a sponsor or, a related party who's willing to back the bond or not? Because that can push companies into all kinds of different situations than, a lease problem or a revenue problem. So I think certainly, the stakeholders do matter in that. Maybe on to Stephen. Stephen, are there any drivers that are more pronounced in today's economic environment, which some may call a bit odd? We've certainly seen some different things, rates and tariffs that are playing factors, but I want to get your perspective on that.
Yeah, and Jordan, you just touched on a couple of them. I mean, when you think about the whole tariff issue, for any business that's importing goods from foreign countries, tariffs have got to have become a major concern. You've had to deal with the uncertainty from week to week whether the tariff is going to be imposed or whether it's not going to be imposed. What if it is going to be imposed? What rate? One week it's this, next week it's that, and that makes it very challenging. To try to plan, accordingly. As a result, we're seeing supply chain issues developing, which further complicates inventory procurement, inventory management. Businesses that aren't staying on top of those issues, could face some pretty serious ramifications, such as inventory levels. You let inventory levels drop because you're not on top of ordering things, to get them in the door quick enough. Now you're potentially impairing your ability to service customers. On the flip side of that, if you try to be overly conservative and increase inventory levels, well, now you got to find a way to finance that inventory growth. Inflation, I say generally is another key driver right now. Obviously as costs increase, margins can take a hit unless you're able to, offset them with, reductions in cost or if you've got the ability to pass along, those cost increases to your customers. But if not, it's going to have a negative impact on the business. I think another one is interest rates. When you think about where we've been over the last 10, 15 years, rates have been unbelievably low up until maybe about 3 years ago. Despite the Fed's action yesterday, it was nice to see a 0.25% drop. But even with that, we haven't seen rates this high from a prime perspective since like around 2007. And obviously, as rates increase, cash flow is the one that takes a hit.
Yeah, just to go off of what Stephen just said, the economic drivers, it's important to note that the Supreme Court's probably going to hear four cases that are going to really set the tone of where the economy may go in the next several years. November 5th, they're hearing BOS Solutions and Learning Resources. Those relate to the tariffs, where the DC Court of Appeals and the Federal Circuit Court of Appeals said that the executive can't unilaterally impose tariffs. That's in violation of the tax and tariff power of Congress. And then you have the interest rates. The rate reduction yesterday wasn't really a result. It was a result of the bad policy of high tariffs, which is really what it is. It's another tax, and that people don't know what it is until who knows. So the interest rate issue is going to be interesting because the Supreme Court is going to hear the Cook case, governor being unilaterally fired by the executive, to put in someone else who may, push economic policy or interest rates that that person wants. The next one is, this one's not getting a lot of play, but it involves what, I don't mean getting a lot of play, but not a lot of mainstream play, because it isn't, it doesn't have the juice, because it sounds like a boring high school or college his civics topic, is the executive impounding funds that were approved and appropriated in a budget by Congress, and that the executive refuses to release. The Supreme Court's also it hasn't been set for argument, but they're gonna hear a case called, one of the cases called AIDS vaccine advocacy. And again, when you look at a lot of businesses, if they get a lot of their funding from the government, whether it's, a postal contract, a military contract, government funding, those I think four decisions and those four cases in those three areas that the Supreme Court is going to have, I think are going to have massive effects on the economy, to the extent that I don't think people are realizing yet, and that'll either help or hurt companies. The other point is also labor. You have, the immigration policies. You see construction going down, or housing. It's not just the interest rates that determine if people can buy a house, it's also the supply. We haven't had a healthy supply since really 2008, during the last crisis. So you're looking at those overlay of macro and microeconomic factors that really companies can't plan for, because everybody likes market certainty. And without market certainty, companies may have no idea what they need to do. They may think, if it goes to what Jonathan said earlier, that what is the problem with the company? Could it be a supply issue today versus a debt service issue tomorrow? So I think those are a lot of the factors, just to go back to what Steve was saying earlier, and how this was going to play out for your company.
Very good. Well, I may stick with you unless somebody else wants to jump in, but we talked a little bit about, the causes of distress. Can we go on to what are the alternatives, kind of for the business to take, and then on the next slide, which will be slide 12, against the distressed business?
Sure. I think you have to figure out which option is the best for the company, because I'm sure everyone else in this panel says Chapter 11 may not be the best option. I had a mentor say to me, anybody can file a Chapter 11. It's having a game plan to get out, because Chapter 11 isn't a long-term healthcare facility. It's not a winery, and it's not a bus station you can use in the winter for the heat and the summer for the AC. So you have to look at your creditor body, your type of debt. Is it an operational issue? Is it a balance sheet issue? Are you having too much debt? Is it a combination? As we saw, Spirit Airlines just went back into bankruptcy after 7-8 months of confirming their plan in the first bankruptcy. If you have we've already talked about Article 9. If you have a friendly secured lender, you can do a friendly sale to the lender. An assignment for the benefit of creditors is also interesting, depending on which state the majority of the assets are located in. I know in certain states like New Jersey, and I'm not sure in Illinois, it's been a while since I've done an ABC in Illinois, because what some of the forms have for those documents, they model themselves after some bankruptcy 363 forms. And then you get to a out-of-court workout. That's more difficult, because one recalcitrant creditor can disrupt the whole deal. You could have the creditor could be owed, $10, and you have 99% of your creditors on board except the $10 creditor. They can mess up the whole deal by filing litigation or having holdup value. Then going back to the Chapter 11 side, are you looking to do a sale? Are you looking to cleanse the debt and do a plan? What are you looking to accomplish? If you're looking to do a sale, most buyers will want a free and clear sale order, to the extent they can get it, to the extent they can wash the company of all their liabilities. Certain liabilities they can't wash. But again, and then if it's going to be a plan, do you have, the thing with Chapter 11, it's so expensive. The advisors get paid first, and then you have your administrative costs to run the case. You have court costs, fees to the U.S. Trustee's office, and then you have to keep your suppliers going. So really, each option, one company just can't say, "Oh, we're going to do this." It really makes sense to do a broader analysis on which one is the best option.
I want to take issue with one thing you said. The cost of Chapter 11. The creation of subchapter 5 of Chapter 11 has been a game changer for me in my practice. It's almost as if from my perspective, over the course of my career, I entered not that long after the bankruptcy code was created, and for a while it was the right, it was the game, it was the best game in town. Gradually it got more and more expensive, and as it got more and more expensive, the world of assignments for the benefit of creditors became more and more of a thing, and it got more and more popular because Chapter 11 was becoming so expensive. It's almost as if Congress said to themselves, we need to compete better. We need the bankruptcy code to compete against. This didn't happen. It didn't happen this way, but it might as well have happened where Congress said, we want to compete against ABCs. They're taking too much of our market share. We want more Chapter 11s again. Because what subchapter 5 of Chapter 11 has done is it's created a very far more efficient and less expensive process for smaller companies who need Chapter 11. So I just wanted to throw that out there.
No, it's helpful. It really feeds right into the question I had for Stephen, which is, how does the size of the company bear on which path to go down, and how does, what's out there, and how does your size and what you've got as far as resources bear on the decision?
In my experience, and keep in mind, my client base is primarily, I'll call it lower to middle market. I don't deal with, real large companies and publicly held ones. So, they could have totally different factors involved. But in the clients that I deal with, I don't see where size really makes much of a difference. A lot of the problems that the companies experience are very similar, whether they're larger or smaller. But both can lack good information systems, needed to provide valuable operational information. I've seen both lack a strong grasp of customer profitability, where they really don't even know, how much money they're making with individual customers. I've seen both have cost structures that are completely out of alignment, with their revenue streams. I've seen both fail to communicate effectively, with their lender and their key business partners. The big difference between the smaller and the larger ones is, the amount of the dollars involved. Granted, larger companies might have, more resources available to them, that might give them potentially a longer runway to try to address their problems, but that really depends upon what the level of distress is.
As Steve was talking, I was just thinking, I'm familiar with Steve's practice a little bit. Steve, wouldn't it be fair to say that most of your situations are either going to be resolved consensually, or they're going to involve a sale, one way or the other, a sale? Yeah or no?
I would add one more. You're absolutely correct, John. The third one is, depending upon the point in time that I get involved which I really don't necessarily have much control over. You know, if things have deteriorated to the point where, you know, a consensual turnaround is not a viable option, perhaps a sale at that point may not even be a viable option, then we're looking at an outright liquidation. And in that case, you know, the goal is obviously to maximize the value of the assets to pay off as much debt as possible.
So that's sort of a segue to a point I want to make, which is the vast majority of I think just statistically, the vast majority of companies that wind up in bankruptcy are companies where equity has no value, right? The debt is clearly far in excess of the assets, and that's why there's a 363 sale. And by definition, a company that commences an ABC is going to sell its assets unless it can't. But there's no reorganizing in an ABC, right? It's only a sale. Now, we could quibble over, well, what if I own XYZ Co. and I commence an assignment and I want to bid for the assets of XYZ Co. It's sort of like a reorganization, but it's a sale, right? Because other bidders could have come and outbid me. And so I guess the point I'm building to is, as we look at this slide, factors affecting a decision, one of the, it's not clearly in on this slide, but a major point of departure, whether you go left or whether you go right, is can the company be restructured in the classic sense? Can a plan be confirmed? If you had to, you being the debtor, if the debtor had to, because creditors won't consent, could the debtor confirm a plan against the will of some of its creditors? You know, could it meet the test of 1129 to confirm a plan? And if it can, or it may be able to, then you're looking at maybe a Chapter 11, or you're looking at an out-of-court workout with the threat of a Chapter 11 in the backdrop. Because if I'm sitting and representing the company, I'm talking to the people on the other side of the table saying, look, if we can't agree here out of court, this is what we're going to do to you in court. So that leads to one array of options. Whereas if we're in contrast, if any day of the week we can't confirm a plan, it's just not possible because there's no equity value left, then it's going to be either a liquidating 11 with a 363 sale, or it's going to be an Article 9 foreclosure, it's going to be an ABC sale, it's going to be a sale transaction one way or the other. So it's just a question, it becomes a question of what's the best vehicle to conduct the sale. And that's where it ties into the slide we're looking at, because the question, if I'm the owner of the debtor and I need to make the final decision, what are we going to do to sell this company? I'm actually stating it incorrectly on purpose. It's not my decision. It's really going to be up to a buyer. If the buyers of the world say, we're only interested in this if we can buy it through a Chapter 11, well, it's probably going to be a Chapter 11. At least if the creditors, at least if there's enough money, or creditors are willing to, secured lenders willing to advance enough money because it thinks that it'll get more in 11 than it would if the willing buyer the best buyer is only willing to buy an 11 and no one's willing to fund an 11, well, it'll get sold for a lot less in another process, probably less expense, but so it's not even the company's decision. Practically, it's not always the company's decision.
Got it. So I want to come back, Richard, to a point you made. You went through all these different factors that companies are facing, and I want to think about where are those showing up from an industry perspective? I mean, are you seeing particular industries experiencing those factors more than others?
Well, I think you're going to see anything, retail, consumer, the restaurant industry, real estate, again, with construction costs. I mean, if you have tariffs on lumber and steel, oil, I mean, energy costs are now through the roof with the budget bill that was passed because of a lot of the clean energy tax credits were removed. Really no industry is immune from any of these factors. And I read an interesting stat the other day that the sale of cardboard is down. I thought that was interesting. Someone had said, "Oh, it could be a recessionary indicator." And if people aren't buying cardboard, if companies aren't buying cardboard, it means they're not shipping their goods. And it's just a domino effect. I think every industry is being affected. I think if and we're a consumer-driven economy, and I think if you have to choose between paying groceries, your housing costs or your fixed costs are food, housing, and energy, those are all going up. Anything else is people are gonna pull back, even in the luxury sector. There's been a lot of recent Chapter 11s, in the housewares industry. We've had several retailers that have creditors circling the wagons. So really, it's almost, with the exception of maybe a handful of defense contractors, I don't think any industry is immune. Some will be able to weather it better. Like if they have enough cash reserves built up, if they have enough inventory, or if they can just draw down on a line of credit faster. I think what you saw in the beginning of COVID, you saw so many companies just draw down on all their lines of credit. I remember when the tariffs were first announced, I reached out to a couple of my lender clients. I said, check all your borrowers, see if they're drawing down on their lines of credit right now, to build up a war chest, either to get through a recession or the uncertainty. And I think also you're going to see another big factor that's going to be in play is pharmaceutical and sciences. So I think really it's every industry that's being impacted.
Understood. Well, John, kind of back to you on these different strategic alternatives. You mentioned Chapter 5. Are you seeing changes in the trends based on today's economy of what companies are choosing?
Other than, I mean, the market reception, if you will, meaning lawyers like me, who have to help clients decide which option to take. The market reception, as I said earlier or indicated earlier, Subchapter 5 is a damn good tool. If the company is small enough to fit. Does anyone know offhand the debt limit?
All I know about is it changed. It
thought
was up and then it went down and it came back up again, I believe.
Last I checked, it was 7.5. I could be wrong. 7.5.
No, I don't think it's that high. I think it's still substantially lower, but that's a misconstrued thing because we confirmed this year a case that resolved about $150 million of debt under Subchapter 5. And the year before that, we resolved a case that resolved about $80 million of debt. And the reason, and those are both in excess of the debt limit, whether it's 3 or 4 or 5 or whatever it is. And the reason is that the debt limit only applies to debt that is both liquidated and non-contingent. So a company can, as long as a company has less than whatever the debt limit is, called about 3 um, of that kind of debt that's absolutely non-contingent and absolutely liquidated, it could have, so the companies, one company we took through subchapter 5, the nature of its debt was massive tort liability, environmental tort liability, but it was in the courts. It hadn't been the number what had not been resolved, so that didn't count towards the limit to qualify. And the other company, it had lease obligations. It had, leases. It was a movie chain, and it had lease obligations that went out 10, 15 years. So the contingent liability was, the tens of millions of dollars, but that didn't count towards the test for qualifying. So pretty large companies can take advantage of subchapter 5 depending on the nature of their debt. And the benefits of maybe we've been dancing around it, we haven't really talked about it, but the benefits of subchapter 5, I mean, right off the bat, there's a matter, of course, there's no committee. There's no U.S. Trustee quarterly fees, but way more important, the test to confirm a plan is different than in regular chapter 11. And by different, I mean easier. And that's really the game changing piece. So companies that might have, that I might have 100% of the time knee jerk towards ABC, I'm now steering toward into subchapter 5. They're more expensive than an ABC, but you don't get to reorganize it in ABC. You don't get to assume your executory contracts in an ABC. Anyway.
Well, Steve, kind of on a related note, are secured lenders behaving different? We've heard a lot of different options from Richard and John. Are they approaching these situations differently from the lender perspective?
I think they are, depending upon, the situation. We've talked about, the tariff issues, the supply chain issues. In those cases, they're seeing those issues all over the place. And so they're paying much closer attention, to things like the borrowing base, availability levels. They want to get their arms around, what are the underlying, drivers of these supply chain issues. If it's simply a matter of parts are getting delayed, they might consider doing a SOFA, an out of formula advance to their borrower to give them the money, to give them the runway to get the product in. But they're only going to do that if they can validate the orders themselves and the margins associated with those orders. If the company's not making money on it, the bank's not going to fund it. In cases where tariffs can't, the cost of the tariff can't be passed along quickly to customers, they are dead focused on liquidity management and tracking that liquidity. They want to know how much runway the company has before it exhausts its liquidity. Because if it gets to that point, the lender's, position might be, we just want to exit the credit, whether it's, refinancing, a sale of the business, but they don't want to get caught, holding the bag once the company is no longer has, enough liquidity.
Richard, we've kind of talked about Chapter 11 a couple times, but we haven't gone over it. And so for our listeners, what should they know about Chapter 11 in a nutshell? And, why might a company choose Chapter 11 as opposed to something else?
Sure. First of all, Chapter 11 is very expensive, especially if you do not go the subchapter 5 route. You have an official committee of unsecured creditors that they can hire their own professionals, lawyers, financial advisors. You have quarterly U.S. trustee fees you have to pay, and you have to pay to administer the case, pay your ongoing suppliers, and the main issue is whether you have a lender who's willing to fund the Chapter 11 case. But before going into Chapter 11, and get to something I said earlier, anybody can file it. You got to be able to get it out. You have to have a game plan going in. Okay, do you want to do a sale of the company? Okay, which assets are you selling? Are you trying to sell everything or just certain intellectual property? Are you trying to get rid of burdensome contracts? Have a list going in the first day. A party can reject a contract. It doesn't terminate the contract, but it basically turns it into a pre-petition general unsecured damages claim. So what the Chapter 11 case does, most importantly, the debtor stays in control when you file the case. It creates an automatic stay against collection efforts against the property of the estate, which is usually broadly defined. If it's going to be a plan, whether it's a reorganization or a liquidating plan, there has to be, and if everybody's not getting paid in full, what they do called cram down a plan over objecting creditors, you have to have at least one impaired accepting class, and it can't be of insider claims. So there are a lot of different mechanisms. There are a lot of different examinations to look at. You'll get a company will get the benefit of a breathing spell, but that only lasts for so long. You have to actually move the case along. You can file a plan, but you have to be able to file a confirmable plan. And if you're doing a sale, a 363 sale, if you have a buyer lined up pre-petition, usually that sale is going to occur within the first 35 to 55 days of the Chapter 11. And once those assets are sold, then you're really just divvying up the proceeds of that sale pursuant to a Chapter 11 liquidating plan.
And just to kind of follow on that, we've talked about many of the advantages of Chapter 11 and how you can reorganize and do other things. Are there some disadvantages that stakeholders ought to be thinking about in terms of Chapter 11?
Sure. Besides the cost, it's a fishbowl. You have to disclose everything. Your creditors are allowed basically to look under the hood, and if they don't think you're complying or with your reporting requirements and your disclosure requirements, they can seek what's called Rule 2004 discovery, basically to get as much, go on a fishing expedition of the debtor's assets and liabilities. I don't think I know we have this line, the stigma associated with bankruptcy. I think that's kind of a misnomer. I think it doesn't occur as much because for a company to file Chapter 11, it's usually a tool. It's not doesn't have oh, you failed at the business, you filed bankruptcy, we're never going to loan to you again. I think companies use it as a tool now to get rid of bad contracts. No matter what the macroeconomic forces are at any given moment, you're going to have mergers that don't pan out. You're going to have bad management that doesn't know how to run a business. You're going to have fraud. You're going to have subject to a lawsuit. You're going to have things that will always occur and cause a company to want to go to Chapter 11. But I think the cost, the reporting requirements, and this is not on our slides, but if bankruptcy is a land of compromises, if you're agreeing to settlement agreements with various creditor groups, you have to keep in mind that how you settled with A is going to impact how you're going to settle with creditor B, C, D, and F. And not everybody's going to get the same treatment in those settlements. And it's up to the debtor and their advisors to figure out a way that creditors could swallow that pill, because it's bankruptcy Chapter 11 is it's like a pizza pie. We're slicing up the pizza. Some people are getting a big slice, some people are getting a small one, and some people may not get anything. So I think those are the main disadvantages of 11, especially if you're going into 11 and you don't have an exit plan. a debtor is gonna lose control of their Chapter 11 case. The debtor always, management stays in possession, but if they've lost confidence in their creditors, there's mismanagement, or the case isn't moving, a creditor group can move to have a Chapter 11 trustee appointed to run the case and kick out the debtor's management, or they can move to convert the case. Say, hey, we're gonna liquidate anyways, why don't we just save ourselves the cost and put a Chapter 7 trustee, and they can liquidate the assets of the company and sue the insiders if we need to.
Thank you. So, John, you mentioned one alternative to reorganizing in Chapter 11, this ABC. Starting around slide 24, can you walk our audience through how an ABC works and what it really is?
Sure. To the extent that somebody's already familiar with Chapter 7 of the bankruptcy code, it would be easier to explain it because it's a lot like that. But I guess I won't assume that everyone in the audience is real familiar with Chapter 7. So, Chapter 7 of the bankruptcy code is titled liquidation. Chapter 11 of the bankruptcy code is titled reorganization. A human being and a company can file Chapter 7 or Chapter 11. And if you file Chapter 11, even though the name of Chapter 11, the name of that title, the name of the chapter is reorganization, that's a misnomer because plenty of companies file Chapter 11 and use it to liquidate or and when we say liquidate, sometimes people draw a distinction between liquidating like in a fire sale, one asset at a time, like in a flea market. You take all your company's assets and you put them in the company's front lawn, so to speak, versus selling as a going concern. But either way, the title is reorganization, yet it's used for sales. The opposite is true for Chapter 7. It's called liquidation. That's the only thing you can do in Chapter 7. You liquidate. And the day a company files Chapter 7, that's effectively the functional equivalent of taking your keys and putting them on the table and saying, hey, Chapter 7 trustee, take the keys. You're now in charge. For better or worse, you're now in charge. And the Chapter 7 trustee's job is to liquidate the assets of the company, meaning sell them, and then distribute the proceeds to creditors in an order of priority that's dictated by the bankruptcy code, period. An ABC is a lot like that, but there's a few fundamental differences. The company, instead of filing a bankruptcy petition, it signs a document. It's a private document. It's trust agreement appointing a trustee. So again, the name, assignment, benefit, creditors. So the company makes an assignment of all of its assets for the benefit of creditors to an assignee, who's also called a trustee, but we just say assignee to keep things simple. We meaning like everyone in the industry. But it's a trust document. It actually has its roots in estate and trust law. So the assignee / trustee, but we'll just call him an assignee, in an assignment in an ABC is kind of like the Chapter 7 trustee in Chapter 7. But when who are the Chapter 7 trustees? They're lawyers, bankruptcy lawyers usually, who not all, you don't have to be a lawyer, but usually it is, who basically is an independent contractor with the US government. They basically apply to be a Chapter 7 trustee. They get a certain number of cases every month randomly, basically, and they're paid a flat fee to administer the cases, plus a success fee, a commission, to the extent that a case has cash that actually gets distributed to creditors, they get a small piece of that. And the company has no control over who the trustee is going to be. It's just it's like a panel, like in the city of Chicago, like the size of Chicago. I'm guessing there's probably about 60 Chapter 7 trustees, give or take. And they just get them assigned randomly. ABC is different. The company picks the assignee. Now, the company can't pick the brother-in-law of the owner. There's an established cottage industry of respected professionals who have a long-standing reputation serving in the fiduciary capacity as an assignee. Steve's one of those guys.
Well, I was going to hit Steve for the next point. You know, if you don't want to do a bankruptcy or an ABC, what are some of the options to just negotiate an arrangement or composition with your creditors? How does that work outside of court?
Well, I mean, you can try to negotiate, an out-of-court restructuring, and those could be either formal or informal, and those could be with the lender, trade creditors, or both. On the formal side, there's what's called a composition agreement. That's usually with the trade creditors, and that's a formal agreement that gets negotiated with the creditors, where they agree to accept, some certain amount of money over a specific period of time, in full satisfaction of their debt. In my experience, I've seen them very rarely, but they exist. From the secured creditor standpoint, there can be out-of-court negotiations there. Those negotiations could involve a deferment of payments for a period of time, extending the length of the loan to give the business more time to pay it off, and in some, but my experience, few cases, an actual reduction in the amount of the debt. What I see quite often in troubled situations is the lenders entering into a forbearance agreement with their borrowers. That's a formal agreement, but effectively it's to give their borrower, a reasonable amount of time to try to implement their restructuring plan before the lender takes, any type of collection actions.
Right. Well, Richard, as we're kind of coming towards the end of the hour, I did think we should come back and talk for a minute about sales.
Sure.
Kind of around slide 19. What are the strategic considerations, both from the buyer and the seller side, the lender side, with respect to different sale options? Outside of court, in court, article mine. How does all that play together?
Well, in court, the buyer, they want a sale that's free and clear of all liens, claims, encumbrances of liabilities. Normally, that's what all of them want. They don't want to do it could be a strategic buyer, which is, a competitor in the industry of the company or of the debtor. It could be a financial, or it could be also a financial buyer. So really, they're going to want the 363 sale because it's quick. They have certainty and they know what is going to suspect or expect in court. They're going to be able to, there's not going to be any successor liability, or it's not going to be deemed a fraudulent transfer of the assets because you're going to have specific findings in the order, in the sale order, that expressly say that. You're going to have a good faith finding that there's no collusion with anybody else. And basically you're going to get an injunction from all the other creditors coming after you to try to collect on their claims against the old debtor or the old co. And the old co, creditors are going to have to get their money from that old co, which is usually out of the sale proceeds. Now, if a buyer is the debtor's pre-petition lender, then what they want to do is called credit bid. And I'll just say what credit bidding is, for an example. It's basically, a lender is not bidding new fresh cash on a company. They are bidding basically the amount that's owed on their debt. For instance, if it's $10 million debt and they're owed 9, they get to credit bid 9 million. And in that situation, the secured lender will want a finding that their liens are valid and perfected. And they're not subject to any challenge, or if they are subject to challenge in a bankruptcy, there's a specific time limit that those have to be brought. And also the lender may just have a better option to sell the company themselves, rather than let the debtor do it. So they may take the company, get the 363 sale order, then turn around and sell it themselves. And from the seller's perspective, they get also the protection of the sale order, and that if people don't assert claims beforehand, they can't collect on their claims as well. So the sellers, it's really a buyer's benefit to get the 363 free and clear sale order. Again, there are certain things that that cannot be that a buyer can't wash of the company, but they can reject anything from collective bargaining agreements, pension agreements, leases and contracts, or for locations that they don't want, suppliers that they don't want. So they can really almost cherry pick the assets of the company.
Well, just as we're coming to the end of the hour, I did want to leave enough time for somebody to raise Article 9 sales and just cover how that works. Maybe if you want to stick with it, or if somebody else wants to jump in on that topic to cover what an Article 9 sale is and how it works.
Sure. The Article 9 sale, it's a sale pursuant to the Uniform Commercial Code. And there, that's usually I like to call it a friendly foreclosure with the company's senior lender. The lender really, they hire their own auctioneer or broker to sell whatever the assets are. The lender, has the sale on site at the company. Usually a debtor gives the lender permission to do so. And you have to provide notice of the sale that's, it's commercially reasonable. The secured party pursues the sale. And again, they are really driving the process. It's not really the debtor or the company at that point, because once the company signs over the right to let the lender, take possession of the collateral, conduct the sale on the premises, the debtor, the company is really, I don't want to say out of the picture, but they don't have the control that they would have in a Chapter 11.
Great. Well, anyone on the panel, parting thoughts? Okay. Well, we do hope you had. Yep, go ahead, John.
Nah, I talk too much. We're good.
No. Well, we hope you had fun today. Slides 5 and 39 both remind you can't go out and make important business decisions based on what you learned, if anything, in this 1-hour webinar. We're not your advisors, you're not our clients, but it was meant to give you general knowledge to help you select and work with advisors, which we all agree is important. So this will conclude our webinar. Thank you for joining another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. Thank you.
Thank you.
Thank you.
Thank you, everyone.